dismiss return.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
November 3rd at 1:30 with Judge Simpson.
November 3rd, 2025, 1:30 before Judge Hammoud.
Good morning, Your Honor. Sam Bernstein with and on behalf of Mr. Nash. Who's approaching? Mr. Nash, could you please state your name for the court?
Brandon Nash.
Your Honor, at this time, people are requesting an adjournment. There are a couple of witnesses to prove this case against that are not present today, so requesting just a 1 week adjournment, please.
Your Honor, we're moving to dismiss based on the prosecution's inability to proceed. It's Mr. Nash's third in-person trip here, and it's been very difficult for him to make that drive. He always has to rely on other people, and so we're asking for dismissal.
Well, two things. Well, the first thing is, so that we're clear, even if I were to dismiss today, the people would be reauthorized.
That's correct, Your Honor. I think the court is familiar with Mr. Nash. He is the person that is currently on parole in Kalamazoo County, and then these cases happened when he came to Washington County. I say these cases, there's only one case today, but there's also a pending misdemeanor matter before Your Honor. It's another retail fraud. So I do intend to reauthorize it, but we're to be dismissed.
So, Mr. Nash, you understand that if I dismiss it, you'd be subject to rearrest, incarceration, and it would be set again. You understand that?
Yes, sir.
And that's what you want to go through? I'll let you think about that a second, okay? Because I don't know that that's what you want to do, but you have a medical marijuana card?
No, sir.
Is the court reviewing the community corrections report?
I am.
And for the record, we did discuss that at Mr. Nash's misdemeanor case, which was up past Wednesday. And if I recall correctly, I do believe the defendant indicated that he was using marijuana without a medical marijuana card, and that his MDOC agents do not test him for marijuana, despite the fact that he is on parole. So I also have receipt of that report that it does indicate continued presence of THC in the defendant's system.
And the court did admonish Mr. Nash that those levels needed to go down. And I looked at the community corrections report, and it looks like we're waiting on the tests that I think were like subsequent to that conversation.
Right. That was on the misdemeanor case.
I think we talked about it at the PCC last time.
But what the problem's going to be is that I'm actually going to be seeing showing up in his system, and irrespective of parole, this shouldn't be in his system on this case.
Right.
For my misdemeanor case.
No, you're absolutely right, Your Honor. And I read the community corrections report that he told the officer, the community corrections agent, that he was quitting, and that the agent counseled him that he needed to quit. So I'm hopeful that those levels are going down.
Well, over the objection of defendant, I'm going to adjourn the preliminary examination in this case. Would the people be ready in a week? I'll let Mr. Nash and counsel pick the date. I can do next week, the 28th, or
People I just confirmed Corporal Andrews, he's not available in November, so we just.
oh, he's not available. Okay, so I guess there aren't really choices.
Next week.
When do you come back and see me on your misdemeanor? I don't have it.
11/15, I think.
Okay.
11/12. I apologize. Or
It would be the 12th. It's either the 5th. I think it's the 5th, right?
I think the 5 is different, but I'm pretty sure it's the 5th.
That
sounds like something.
Huh?
Can I say something, Your Honor?
Sure.
I have not been smoking. And when you told me to stop smoking, I stopped. And they making it seem like I'm still smoking weed. I'm not smoking no weed. I don't do drugs. When honestly, they making it.
Go ahead. I'll let you finish.
They just making it seem like I'm just still using. I'm not. I'm taking care of business like you asked me to do.
Hey, Mr. Nash.
Yes, sir.
I remember you telling me that. I'm also looking at these test results, right? If I thought you were just out there doing what you think that the assumption I'm making, what they're saying, then I'd solve that very quickly because you'd be incarcerated. I'd make sure you're not smoking. All right. It's not like I don't hear you and don't listen to you in terms of what you're saying. I recall that. All right. But from their perspective, this is to understand, it's appearing in your system, right? The only question I have is whether or not we can get results in terms of levels, which is really going to tell me. Okay. So trust me, and you've seen me before. When I make a decision, I'll make a decision. But I haven't made a decision. I'm trying to give you the benefit of the doubt. Follow me?
Yes, sir.
All right. Is when he set the night. We went all the way out to the 19th?
We did.
Okay. All right. Here's what I'll do. I'm going to, over the objection of defendant, and given the status of these reports, and he's got other matters pending before me in any event, I'm going to adjourn. I'll adjourn it out 1 week to October 28th, 2025 I'm at 9 that day.
You can't assume these hearings are like important hearings.
9.
Is that before Your Honor?
Yes.
Okay.
That will be before me. I'm going to set it on that date. I'm actually covering for Judge Washington, but this one will be before me, certainly. And all right. And then we can, if they don't have their people, then I can make a determination at that point.
Thank you, Your Honor.
All right.
Got it. Thank you.
All right. Bond will continue. All right.
Thank you.
Wait, 1 second.
Is that your only case, Mr. Brown?
Been so long.
Court calls the case of the People versus Brandon Nash.
Good morning, Your Honor. Sam Bernstein with on behalf of Mr. Nash. This was Mr. Mayville was just here. Should I go step outside and try to locate?
No, you stay right there, Mr. Jerkus. Just coming back.
Mayville for the people, Your Honor.
All right, I have before me a plea form that indicates the defendant is going to be pleading no contest to the charge of retail fraud in the second degree. The 1-year offense upon a successful plea to that charge, count 1 would be dismissed. That's the court's full understanding of the agreement.
That's completely accurate.
That's correct, Your Honor. And I don't know if Mr. Nash, did you say your name for the record?
Brandon Nash.
Thank
Your Honor. You're welcome.
May I have him?
Raise your right hand. Do you solemnly swear the affirmative testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name.
Brandon Nash.
Sir, it is this court's understanding that you're going to be pleading no contest to the charge of retail fraud in the second degree. That's a misdemeanor, punishable by up to 1 year incarceration, a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that?
Yes, Your Honor.
All right. Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it I have to make sure that you understand. The first thing is it means that you're not further desirous or wanting to contest this charge. Do you understand that?
Yes, Your Honor.
The second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
All right. Still wish to plead no contest?
Yes, Your Honor.
Basis for the no contest plea?
Potential civil liability, Your Honor.
And sir, to the charge of retail fraud second degree, how do you plead?
No contest.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form, is that correct?
Yes, Your Honor.
Any question regarding any of those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand that by pleading no contest, you're giving up those rights as well as all the rights contained on that form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
Yes, Your Honor.
All right. Were you on probation at the time of this offense?
No.
All right. Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No, Your Honor.
Has anybody threatened you or coerced you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided Pittsfield Township Department of Public Safety report for their case number 254132. Any objection to the court having reviewed that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Sir, I do have to advise you that if you commit misconduct between the time of my acceptance of your plea and the time of sentencing, the court would no longer be bound by any sentence evaluation and or recommendation, and you would not be entitled to withdraw your plea. You understand that?
Yes, Your Honor.
Is counsel aware of any other promises, threats, or other inducements which have led to this plea?
Not specifically, Your Honor, but I do believe that the defendant was on parole at the time of this offense.
Sir, is that correct?
Yes.
All right.
Yes, Your Honor.
So I asked you whether or not you were on probation or parole. So you were on parole.
Yes. Yeah.
I then do have to advise you that your entry of a plea in this case could be a violation of that parole. You understand that?
Yes, Your Honor.
You understand that as such, you could be sent back to do the tail or the remainder of your prison term. You understand that?
Yes, Your Honor.
And understanding that, do you still wish the court to consider accepting your no contest plea in this case?
Yes, Your Honor.
All right. And Mr. Bernstein, are you aware of any other promises, threats, or other inducements?
No, Your Honor.
And correct, Your Honor, I'm not aware of anything else.
All right. And have I complied with the court ruling? Would it be proper to accept this defendant's plea?
Yes, sir.
Yes to both, Your Honor.
All right. Court will accept the defendant's no contest plea to count 2. Count 1 is dismissed. A pre-sentence investigation and report is ordered at 14A1. Probation sentencing in this matter will be
December 10th at 9 a.m.
just say it again.
December 10th at 9 a.m.
Nothing between those two dates. Then.
No.
December 10th, 2025. You said 9 a.m.
Yes.
9 a.m. That is before me. Bond in this case will continue. Thank you.
Your Honor.
Thank you, Your Honor.
Thank you. You can stop down at my probation department to start the process with them. They're on your left as you go down the hallway.
Okay, thank
All right.
you.
Thank you.
Well,
Court does call the case of the people versus Michael Russell.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Michael Russell, who approaches.
Your name, sir?
Sorry, sir. I was in a slip and fall.
Okay.
I'm in excruciating pain. I think I need to
Can
speak with.
you tell your
Assistant.
name now?
Can I speak with my attorney? I have some misinformation.
You state your name for me.
Oh, sorry, sir.
Let you say what you're gonna say.
Michael Russell,
Thank you. All right, where are we on this?
assist other law enforcement, trespass offense. This was generated yesterday.
Yes. So from what I understand, there are aspects of the police report that Mr. Russell is asking to discuss with me further. I did show him the police report that was sent to me by the prosecutor's office last night.
This was created yesterday.
Would the court consider passing the case so that I can meet with him?
Sure. I will do that. I thought you might be ready, but okay, I got you.
I'm
All right.
sorry, Your Honor.
No, it's okay. I've got other things I'm waiting on, so it's not a.
Thank you, Mr. Simpson.
I'll come meet with you.
Court does recall the case of the people versus Michael Russell.
Kenneth Overwater, Assistant Prosecuting Attorney for the People.
Assistant Public Defender Chelsea Vergils with and on behalf of Michael Russell, who approaches. Mr. Russell, please state your name.
Michael Russell, for the record.
Your Honor, thank you for passing this to allow me to speak with my client. I have provided the court with a preliminary exam waiver form. I believe Mr. Russell is very much aware of his right to a preliminary exam. There has been an offer by the people in circuit court that he is interested in, so we are asking to waive his preliminary exam.
Did you wish that offer stated on the record?
Yes, Your Honor.
Thank you, Your Honor. If this matter went to preliminary examination today, the people would be seeking additional charges of resisting and obstructing causing injury, as well as potentially one other additional count of resisting and obstructing. Pursuant to Mr. Russell's waiver and plea of guilty to the existing current counts 1 and 2, the people will agree not to seek additional charges. Further, the people will also agree that he may plead no contest to those existing charges 1 and 2 on the issue of potential civil liability, and the people would further agree to a sentence of probation with no prison term. Any jail term would be up to Judge Hammoud, before which Mr. Russell would be sentenced.
And a correct statement.
That is our understanding of the plea.
All right, Mr. Russell, you're going to waive your right to a preliminary examination?
Yes, Your Honor.
All right. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
I understand, Your Honor.
You understand you will not have that hearing and that you'll proceed to circuit court for further resolution.
Understood, sir.
All right. People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendants bound over to circuit court on counts. Ms. Reed.
We acknowledge receipt of the information, waive its formal reading, and stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial in this matter will be set for
November 3rd at 1:30 with Judge Hammoud.
November 3rd, 2025, 1:30 before Judge Hammoud.
Your Honor, may I address bond?
You may.
Your Honor, we're asking for a personal bond in this case. This is the only thing holding him at this time. My client stays in Washtenaw County. He has an address with a relative he can stay with. He has a good relationship with his family, has been in communication with his mother, who is supportive of him. He also helps take care of his father, who is at a senior center in Milan. Close with his siblings as well. He's employed in construction and cleaning, has his own business. He really wants to get back to that. Of utmost concern to my client at this time are his health issues that he is suffering from. He has high blood pressure, which can be very dangerous, and is had a recent fall at the jail that severely injured his back and neck. He believes he needs to go to the hospital. He would like to seek medical treatment for that urgently outside of custody. So to be with his family, to continue work, and to seek that medical treatment, we're asking you to consider a personal bond.
Respond.
Your Honor, the people would object. Facts of this case, Mr. Russell was found trespassing at a lot in Ypsilanti. Officers observed him as someone who matched the description, been there the night before, and was believed to be stealing items. When the officer said to stop, he ran. Additional officers arrived on the scene and chased him. He hopped a fence. 2 officers hopped that same 10-foot fence, dropped down. The officers were injured. One in particular suffered scratches on his arm as a result of this. Mr. Russell still refused to stop. Eventually, he had to be tased in order to stop him, and then he was taken into custody from there without further incident. This is not the first time that he has gone to the police. He has a history of resisting, fleeing, and eluding. He's been sent to prison for this on multiple occasions. While we have reached a resolution of this matter that does not involve prison, the people believe that he should be released after this case is ultimately resolved with the proper safeguards and guardrails in place so that he can maintain whatever his issues are and get those under control before his release.
Anything from?
Yes, Your Honor. Although he is interested in that plea deal at this time, the allegations remain allegations. This is the only thing holding him. I believe Mr. Russell would attend future court dates and fully intends on complying with any probation he's sentenced to. I would ask the court to consider release on a tether, if not just a personal bond.
Well, given the fact that there were, they said, alleged that officers were injured, but also he does have a history of flight from authorities, the court would consider him a flight risk at this time. I'm going to deny your request. Certainly, Judge Hammoud can take a look at it and make a determination as to how she wishes, if the defendant's released, how he would be released in the circumstance. So, motion's denied, bond will continue. Thank you.
Thank you, Your Honor. Have a great day.
Thank you. You too, sir. Court does call the case, People versus Jermaine Palmer.
Michael Gaddy, Assistant Public Defender, on behalf of Mr. Palmer, who's making his way up to the podium, Judge.
Your name, sir?
Jermaine Palmer.
Thank you. What are we doing?
Your Honor, this is the date and time scheduled for preliminary examination. However, the unnecessary witness, Your Honor, this is a case that was up previously. There is a great deal of concern because this defendant has contacted the victim in this case. At the time that the jail calls were listed to, originally at that point, 43 calls since arraignment. I believe his phone privileges were revoked by Your Honor at the last hearing, and that Your Honor indicated that you would allow motion for forfeiture by wrongdoing if that would be necessary. We are here today. The victim is not present. Ms. Zenda has listened to the jail calls. We have a description of the jail calls. I was able to forward those, or at least a link was sent to Mr. Gaddy yesterday. Get Mr. Gaddy and myself yesterday. Essentially, on the jail calls, that's my understanding, that there's clear instructions to the victim from this defendant on what to do, what not to do as it relates to cooperating with prosecution, details on how to dismiss the case, telling the victim to contact the prosecutor's office and tell us that she is not pressing charges, to tell us that they only got into a verbal argument. I could go on and on. There's plenty there, Your Honor. Needless to say, the nature of it, we believe, is a good basis for a forfeiture by wrongdoing motion. And so we would need some time to file that. I'm sure Mr. Gaddy needs some time to listen to those calls, as we were only able to provide them to him yesterday.
That's correct, Your Honor. We did receive those yesterday. I believe they were downloaded this morning. I have someone doing a preliminary listen as we speak, but I have not heard them. Looks like the calls, I think his phone privileges were revoked some time ago. We're prepared to go to exam. I understand the people are asking for an adjournment, and we'll leave that to the court's discretion, given the fact that they would probably reauthorize. And if the case were dismissed, he would lose any credit for any time he's got it going now.
Revoked his phone privileges once knowledge came to the court on October 9th. And at that point, there was contact. I don't think that it was specifically told to me what all the substance of the phone calls were. I'm a bit disturbed by what I'm hearing today regarding that. I will grant the people's adjournment for a preliminary exam date in this matter. I'll adjourn it to my next available date where I'm not covering, but to give them time to do that. Will be adjourned to 11/25/2025 at noon.
Yes.
And at any point I can hear the motion once it's filed on that.
Thank you.
Defendant's bond will continue. His phone privileges remain revoked. Thank you.
And Your Honor, if we were to file a bond motion or release any kind of a modification motion, that would be before your honors.
Yes, it would be. And I would indicate, certainly I will hear any motion, but if I were to see something where it appears that the defendant is interfering with these proceedings, it's hard pressed to release. I think you know that, Mr. Reddy.
Yes, thank you.
All right.